So again, hello everybody who joined us today for Ready Set Space Sun or Space Apps Network Roadshow. We have quite impactful, quite productive 2 days going on right now. So yesterday we already kicked off with 2 of the sessions of the roadshow. So we had a session on space entrepreneurship and space funding, and today we are continuing our roadshow with one more exciting topic. So looking into the agenda today, we'll be starting off with the space law topic. We have 2 presenters today joining us, so Efrén Díaz and Carlos Albareda, who will be presenting the space law topic. In the afternoon, please stay tuned. We'll be also having yet another session starting from 1 o'clock. That will be for space accelerators. So there we'll be having a space accelerator session. So stay tuned for that. One more session for today. We'll be having some fruitful presentations, hopefully. You will find this information, what you hear today, useful. So going a bit further, I would like to briefly introduce SUN, or Space Apps Network, and why we are here. So basically, with the Space Apps Network project, we aim to build bridges between existing space initiatives and match startups with suitable support programs. We also organize these individual tailored one-on-one mentorship programs and events like these. So like this one, so hackathons, roadshows, webinars, just to spread information about space and to attract more businesses to join space sector. So speaking about our mentorship programs that I have already briefly mentioned, we have currently an open call going on for a couple of our mentorship programs. So pre-incubation for early stage entrepreneurs, and for a bit more advanced entrepreneurs and startups, we have a pre-acceleration program going on. So if you're looking forward to further develop your idea and concept, improve your investment readiness, and you're looking forward to maybe also apply to other space programs like ESA incubation and various other accelerators, and match yourself with potential investors and clients, also attract investment, you're in the right place. The universe is calling. We have an open call going on for actually 1 more day. It is open until the 3rd of June. My colleague Justina just pasted the website where you can apply. So we have a pool of over 70 mentors available, and we can provide you from 12 to 24 hours of specialized mentorship support. So do not wait, still 1 day to apply. You can do this right now. And if you need more information about this, you can contact either me, the contact details are on the screen. So me, Inga, or my colleague Martina, we are both representing Space Apps Network. So now going into our session of today, we have a really exciting session coming up on space law. So first of all, we will start with our presenter, Efrén Díaz, who is head of technology and space law at Bufete, Calvet. And he will represent legal needs of the space industry and startups in new space. Then we'll continue on with Carlos Albareda, who's also representing Bufete, Calvet. He's a lawyer of space in there. So he will be representing a topic of intellectual and industrial property for startups in new space. So right now, I would like to give a word to Efrén. The floor is yours. I'll stop sharing right now so you could share your slides and we can go ahead. So Efrén, the floor is yours, please.
Sorry, Inga, because my laptop just restart now, so I'm going to share the screen. Just a second.
That's all right. Just everyone just bear with us. Some technical issues going on, but we will solve it fast.
I'm sharing the screen. So sorry for the technical issues. Now, thank you for the presentation. I hope everyone is seeing the screen. It's okay?
Yes, you can see your screen. That's perfect.
So thank you for the presentation and the opportunity of share these topics. So I would like to talk about the legal needs of the space industry for this sector. And the first topic is the evolution towards new space. In this sense, the evolution to new space present a fascinating risk in terms of businesses in the new space. We can see current needs and enterprise business models, because there is a new paradigm for space companies. In this idea, this new spatial paradigm means new needs in legal terms. For a new legal framework, because traditional space is not the same as new space, so corporate and contractual framework must be seen to develop these new needs. And also we must work through administrative authorizations, own and third-party liabilities, and greater legal and compliance strength. From these current needs, the new business models in space activities offer us as law firm and as lawyers these ideas that I would like to share with you. Internal legal relations with the partners involved is key also for the companies and their activities for and in space, because space is mainly done on Earth, and also the external legal relations, like the relations arising from the activity. Also, the relationships with public administrations are very important in the arena of applications, licenses, and authorizations. And finally, the products and services that require contracts, terms of use, permissions, copyright, etc. From this perspective, also next generation aerospace funds creates new requirements, and I would like to share with you what is more or less the main panoramic view for the aerospace sector. Today, aerospace sector is seen as global strategic industry sector, based on the specific weight in overall industrial production, all the impact that the aerospace industry creates in social, economical, and policy area. And for that reason, at least for instance here in Spain, the government say that the role of traction in the innovation ecosystem and other industries of aerospace sector is very relevant to offer new activity sectors, new economical sectors. For this reason, the aerospace sector is in the core of the transformational capacity of the economy and labor market. And for at least these three pillars, aerospace is one of the key and more relevant sectors for the next generation funds. First, for its strategic importance, also for the capacity to mobilize different industrial sectors, because it's very common in the space sector, all the chain of providers, industry connected, etc. And also the tractor effect of its actions in the R&D field, which means the innovation, the development of research, etc. These pillars are in the base of the consideration of next-gen space funds, and is a very interesting sector to achieve funds, especially if you are a startup or a non-consolidated company already. So in the funds, at least from Brussels, are looking for the capacities of the companies, which is close or connected to the key to economic empowerment. And also, as Brussels recognized, there are many challenges because economic, social, scientific, technical, and regulatory retos or challenges in the sector. For that reason, the funding is on the is based or after the health crisis and also now with the economical crisis. And the grounds are also looking for the essential basis for public and private partnerships. So have your company legally fit, legally well done, help you to arrive to these funds in the aerospace industry. We can see this strategical perspective also connected to the technological development and the operational evolution of the new space. And legal certainty makes sense in the area of the complexity and challenges of space activities. And for this reason, I would like to jump into the more deep details in the spatial legality. Spatial legality have a very wide area of topics. Just to be clear, I would like to suggest at least these 3 points, like corporate configuration, data processing, and damage by space objects. Are just a few of many of them, and later on we'll see some of them in the compliance area. This means that the spatial legality is made by international and national regulation, and for that reason many times we have the difficulty to determine which level of regulation apply to certain company. I would like to talk at least from the European perspective, some examples applying Spanish perspective, and we know in certain activities we will launch the rocket from outside of Europe. So international regulation is also implied in these topics. So corporate configuration and human resources of space companies require legal forms and the decisions on the legal form. Legal forms of companies create activity. We must know activity to be developed, geographical deployment of the activity, especially when we are acting in Europe, but we are also developing activities outside of Europe, and also the jurisdiction or territory in which we are acting. This perhaps looks some theoretical, but we'll see now the importance of that. Not profit or a profit means the decision of be an association, be a foundation, both are non-profit organizations, and societies or corporate companies be profit companies, and we have to determine which form of company is useful for the activity we would like to do. The decision of the legal form requires a preliminary legal analysis to determine the composition, the capital, and the activity. After see that, activities to be carried out by the company also determine which kind of legal form we have to decide. Also is key or relevant the involvement of members or partners inside of the company in terms of know how to do with the company, and at the end final financial structure and legal actions to be taken determine all this galaxy of lines to determine which is the best legal form. After we have our company, used to say, we also have to deal with the data processing, and it's very relevant in the space activity. The processing of personal data sometimes is seen as something not applicable in the space activity, like say, well, satellites and rockets has nothing to do, or nothing to do with data process, or and not only personal or not personal. Come on to see some keys, regulation, obligations, data flow, and specialties in these sectors. From my point of view, one of the key of this point is that privacy is a European fundamental right. This means that it also is applicable to a space activity because it's a cross-cutting and universal application regulation. So applies to any data, personal or not personal data, and also in Europe and outside of Europe. The evolution from files to processing is also very relevant because we are now in a cloud computing environment, and also the rules try to push the space activity from formal compliance to effective compliance. The change of mentality we can see so easy from files, from this kind of supports to cloud computing, and also this is applicable to a space activity. And also when we are processing data from satellites or other space infrastructures. And from formal obligations to obligations of results, this means this is not just a question of comply with certain checklists, it's also very relevant, comply effectively, and also doing the space activity in legal manner. Some clear concepts require the distinction between personal and non-personal data, file, or processing, all the activity we are doing with that. And three relevant concepts also are data controller, which is the person that determines the decision on the data, data processor, data controller, data processor, and subject of data. Also, the regulation is global, and especially if we see from the European and international perspective, because just to mention three big areas of regulation in this topic, we have the California Consumer Privacy Act, focus on personal information and consumer, but in contrast, GDPR is focused in personal data and in citizen data. So this means the citizen is in the focus, not just the consumer. And Japan and Asia have some correlation with Europe because Japan at least has signed a big deal with Europe in terms of processing of data. Just to mention at least three areas of big spatial activity. Also obligations for your company, at least just to list some of them, is based on the records of processing activities. These records are focused on data, file, and processing, knowing that data is not just the support and processing is much more than files or supports. Also, the protocols are relevant because must be dynamic and flexible just to adapt the different scale or different sizes of the companies. It's not the same just a startup than a big company. And these protocols arrive on legal text. Some of them can be mentioned just to distinguish from legal notices, privacy policy, and cookies policy. Usually are not the same, although in the websites are sometimes in the same page. And compliance, at least in the European legal environment, is seen as something related with criminal actions, criminal preventions, but is much more than crime, and also compliance affect data. And mainly in the space activity sector, the processing of data is something key in all the activity, because what's relevant with the satellite is not just get the satellite into orbit, it's all the data processing doing with or through the satellite. Some companies ask us which is the main documentation. So the documentation that you must have as company is based on your responsibility. And this means that your responsibility requires be proactive as the GDPR established. So you must have documents to demonstrate what you are doing. And as I said, it's based on the principle of proactive responsibility of GDPR. That means you must comply with the rule. And to comply with the rule, you need at least data protection document as demonstrable documentation to show you are doing things correctly, and also the informative text. Some of our clients ask usually, which is the distinction about informative text? And the distinction is mainly offline and online. So we have two areas of information. After following the regulation and complying the obligations, data flows are something important to know and to analyze in the space activity, because these flows sometimes are not visible from the very beginning. This means that at least we have to know which subjects are doing or are affected by the processing of data, which purposes of this data through satellite activity, through space activity. Imagine use vehicles, automotive vehicles, Internet of Things, used to activity imports with boats about GPS and how to process all the information through airlines, etc. So purposes is important, and also conditions. Subjects, purposes, and conditions probably help you to analyze 3 big lines to specify which data flows are involved in your spatial activity. Just to help more, main data flows can be based on a space enterprise activity. Use be a company require some data processing. Also, parties involved, your company, your providers, all the contracts you must sign, all your collaborators, etc. Later on, phases of a space project development, because it's not the same the design, the launch of the rocket, and the management of the satellite, or the download to Earth of the information from the satellite. And for this reason, can be helpful have a clear structure and content necessary for legal and administrative proceedings. This means, although you have your company, although you have your providers, later on we must ask permissions, authorizations, administrative proceedings, which require shared personal information, non-personal information, satellite parameters for orbit, etc. Finally, I would like to share with you some big specialties in space activities, because a key distinction is, as I mentioned, personal data and non-personal data. Second point is support is not just processing. Imagine you can externalize your supports. Imagine Dropbox, Amazon Web Services, or whoever other providers that can support your activity. So it's important, because in that point, if you externalize the service, we must check the contract to do that activity. And also is very useful know the phases of a space project as something progressive, because it's not the same the A phase, like analysis development, will require company data versus project data. Phase B, design, is critical for personal data. You can determine in that moment not process some personal data because legal reasons. The phase C and D, following the common structure of space activities, development, manufacturing, integration, and testing, also have the big problem of cybersecurity. And launch also is a low risk activity in terms of data processing, but at the end, operation, maintenance, and decommissioning have high risks for data processing. And for, just to summarize, data protection, intellectual property, dual use technologies, and liability for damages create big environment of legal needs that we must comply with it. To see the damages in the space, the liability for damages is a very common topic connected with the responsibility and with the outer space law. The responsibility is very common and is very well analyzed from the regulation. So the responsibility can be objective and subjective. For damages, this is a general legal issue also for Earth damages, but in space has been regulated from this very old Outer Space Treaty, and not more recently, but more specified in this Convention on International Liability for Damages Caused by Space Objects. And this is a very old regulation, perhaps required to be updated. And I don't know exactly if we can use this regulation in new space activities, because this treaties were thought for big satellites, more institutional space activity. In outer space law, of course, is applicable the general theory of civil liability, like if you cause damages with your car, but the essential elements that you must be concerned are some of them. The event given rise to the damage, the damages itself, the causal link between that event and that damage, and also the existence of intent or fault. This is common in any kind of damages. But the problem in the space law is there is no previous link between victim and the tortfeasor. So this means a satellite or meteorite can impact in International Space Station, create problems, and there is no previous link between a contractual relationship between the meteorite and something that crashed into the International Space Station. So this creates big problems. And the second big problem is because this lack of link, we cannot check what happened previously because we cannot go again to space to see that outside of the Earth. So very often non-contractual liability is there, and your company can be affected by this because the damages can be material or immaterial. Imagine you lose the satellite or your launch becomes into fall because crash before be outside of the Earth, etc. Also, the spatial objects can be affected. Imagine you put a satellite in orbit and other things crash into it and you lose all your hardware and software and information, can be a big problem. And also, who are the active and passive subjects, who has the capacity to claim or to be claimed. So for a space mission stages, this responsibility can be seen in pre-launch, launch, and post-launch moments. And this can be helpful to determine who has to pay the damages and be paid by that. After see that, I would like to go through the regulatory compliance to see 3 points where your company or space activities create big impact. So dual use is applicable to products and technologies. So in dual use is affecting to nearly everything connected to a space activity, also in connection with civil, military or nuclear uses. Spatial activity include systems or systems, elements and components. So create all the hardware, all the software, and also the technology or the technology transfers are affected by dual use, which require authorizations to be able to make transfers to non-EU foreign countries, and your company to transfer, to be authorized to do transfers or exportations must be required in the Special Register of Foreign Trade Operators, which is based in each country, at least in the European Union, and from that you can ask the permission. So although I put in the latest point, this is the first step, be registered in these foreign trade operators as operator to ask the authorization for a special activity when you are inside of activities that can be considered dual use. Export controls is regulated in Europe from this regulation from 2009, and also in the Spain regulation, just to show national regulation. But this regulation applies to every export control of products and technologies all through the European Union and outside. And outside because imagine if we buy something in Brazil, we import it into Spain, we send to Germany to be assembled, and we send in a satellite from US launch rocket, we must apply the regulation of the European Union, because although we buy in Brazil and we launch from US, we do some activities in Spain and Germany or any other European country. So extraterritoriality apply and create some big legal needs to be clarified on. Licenses and authorizations also create some important legal activity, because the impact of space activities is followed by the states. The responsibility is of the state, besides the state can claim to your company. And this is applicable to different areas like safety, environment, taxation, security, protection, urban planning, export and import, etc. So we are in front of several sectors, different authorizations, and for that reason, the administrative intervention for the supervision, management, and control is always there, and we must deal with that. There are different authorizations. Just to mention 3 examples: control authorizations, you cannot do nothing without that. Also, program-based or operational authorizations. After you have the authorization, the operation requires other licenses. And finally, authorizations linked to the applicable regulations. Imagine nuclear weapons. Although you have authorizations and you have operational authorization, perhaps you cannot get authorization to do something as a weapon in the space, because you have nuclear energy or other sectors high qualified regulated. Orbit spectrum resource is also important, because usually, as you probably know better than us, satellite infrastructure is something necessary for the mission. Orbits require also authorizations to know in which orbit we are, or is ground segment. And usually this orbit spectrum resource is under public domain, which is required for communications operation. And for that reason, a space service give the administrative concession to do what you need to obtain orbit spectrum resources, like the line from Earth to space, space communications, or space-Earth communications. The current regulation is focused in orbit spectrum resource through the International Telecommunication Union, is also related to the sphere of sovereignty of the states. And there are different general regulations, but finally, the special regulation is under the use of the public radio domain, and we must put all these points in order to present the requirement of orbit spectrum resource. And finally, just to talk about the space debris after the mission, what there are, threat and prevention, to finish in time. Space debris is not just fragments. There are different kinds of space debris orbiting the Earth and create threats to the future in the space because of the amount of them, creating risk for operational satellites and space operations and missions. This means that this threat is very relevant for the ESA Space Debris Office. Both waste situation can create explosions and collisions in space. And finally, the international guidelines and standards for sustainable use of space require the deal with this space debris. The prevention is there, and for this reason, I would like to show some of preventive actions that determine also legal requirements. Design rockets and spacecraft to minimize a launch and operation, as minimize the impact of space debris after the operation. Also avoid explosions with release of stored energy. Imagine you have a satellite in orbit, and because have no prevention actions to avoid that, you can create explosions affecting all what you are doing. So passive spacecraft after their activities is also important to avoid collisions in the space. And the orbiting, which means move the missions out of the orbit of operating satellites, is key to avoid impacts between operating and non-operating satellites. And finally, the carefully choice of orbits require the selection in which orbit you are acting and the impact that you can have as a space company if you are managing a satellite that can affect other orbits with the impact that this can have. So thank you for this, and just some conclusions to recommend some big appropriate legal framework through the effective regulatory compliance. Second, know the legal issues, more at least this and others, to do the best technical, economic, and business development. Get the professional experience to achieve legal and juridical implications in the space sector and be protected against problems, and also developing the business with legal certainty. That means legal safeguards and avoid sanctions that can be imposed to your company if you don't follow these rules. Thank you so much for your attention. Muchas gracias, and I'm here to attend your questions.
Yes, Efrén, thank you so much for your presentation. And now we are open for a Q&A session. So please let us know if you have any questions, and Efrén will be happy to answer them. You can also post your questions in the chat. You don't have to voice them over. If there are no questions at this time, I guess I can give a question from my side. We had some questions from our colleagues from the Space Apps Network. Efrén, what would you say would be the key legal challenges that the space startups face?
Yes, this is an important question. In my concern, the main question is know that legality implications are there. Many times, imagine a company that start to build or create a satellite or Internet of Things, etc. They are focused on tech implications. So sometimes they discover that the law is there when they would like to send the satellite, not just to the space, just send from one country to another, and they realize that they cannot do that because they didn't follow the law from the very beginning. So this is one point. Know that the right is there. Although you are a startup, please follow the law, because it's a very good way to avoid problems later. And second, see the law as one of your support. Like you contract an engineer to develop the satellite. Perhaps you need also the advisory of a lawyer, a space lawyer like our law firm, to support your activity in legal terms. Because sometimes we must do things before start to build the satellite, just to follow the example of the satellite. So before the satellite, you must set up different legal questions, and it's very important to analyze your company, your activity, what you want to do, and how you are doing that, not only legal in tech terms, also in legal terms.
So would you say, like, before then you have like any kind of idea, you should check it first if it's possible in the legal way before you start developing it, because it might not be?
Yes, answer also the question in the chat. It's not easy to offer just a website, because I suggest the website of UN with the regulation, because more or less all is there. But is not enough for you. So I think activities like webinars like this that show implications. Going back to my presentation, first decision, know if you must be an association or a company. If you decide to be a company, know what is your activity, because although you are working, imagine creating solar references or solar panels for a satellite, that is not the same as operate a satellite in orbit. So clarify what is your activity. And finally, knowing who you are, company or association or foundation, and knowing what are you doing, as someone asked, so regulations, space industry, satellite service, and bandwidth, all those topics are connected or not, depending on your activity and what you are doing. So my suggestion is, as soon an engineer and a lawyer to develop better your activity as a startup.
Okay, thank you very much, Efrén, for this. Yes, we have a question from Joanna. She says, do you think that the absence of laws foreseeing the use of space resources is a major cause for the lack of investment in upstream projects? Right now, the only legal and profitable industries seem to be data collection, processing as such.
Yes, I see like 3 questions in 2. So first of all, of course, the lack of enough law in the current new space environment is a big problem. It's like, let me do an example. It's like start a football match without rules. What is goal? We don't know. So lack of law creates huge uncertainty. That's a big problem. That big problem of uncertainty, so uncertainty is like against money. So investors don't like so much uncertainty. So lack of law sometimes create lack of investment. Is very close. So big legal security create big economic security sometimes. And finally, of course, today the new space activity is much more than hardware, is much more than the satellite. And probably the interesting activity in the new space is the software, data processing, etc. So data processing is not just talk about personal data processing. It's talk more about much more than data. It's talk about your information, data, information, knowledge. That's new space, more or less. So I think that data collection, processing, and all what you are doing in the point of the chain in which you are as a startup require legal clarity about what you are doing and know if what you are doing is legal or not. Because for technical problems, usually you are not fine. For legal problems, you will be fine, as we know, by speed limits in cars. So that's common in law.
Okay, thank you, Efrén. I guess if there are no more questions in the chat, I'll ask one question from my side again. What do you think would be the #1 priority from the legal point of view for a space entrepreneur? From a legal point of view. So if you're just starting as a new, fresh space entrepreneur, what's the first thing you should do from a legal point of view? Where to start?
I think clarify your legal form. If you are going to be as person, natural person, or as company, and also, although it's outside, and probably my colleague Carlos is going to talk, don't think only in patents. My perception is many startups think from 0 to 100. From 0, nothing, to have the patent tomorrow. There is much more in legal terms. So know who you want to be, and also get the support of legal space lawyers to help your activity. Like you need engineers to do what you need. Igor, I think I see the...
Hi, thank you. My name is Igor. Thank you for your presentation. I have a question for you. Are there any websites that you would recommend that contain an actual database or just a list with brief description of regulation regarding space industry, particularly satellites, orbits, and bandwidth, that is easy to navigate and study for a person like me without legal knowledge and background? Thank you.
Yes, so I haven't got a specific website. I'll share my email because I just finished an article trying to summarize those legal needs. So feel free to write me, and after that, if you don't mind, I'll send you some articles. Probably I can translate for you into English. To offer you like a panoramic big legal main points.
I will appreciate that greatly. Thank you. I will contact you soon. Thank you so much.
Thank you.
Okay, I guess one more question from our side before we go into break, because afterwards we'll have a 10-minute break until another presentation. So yes, one more question would be, what would be the most important legal documents space startups should be aware of? So if you had to name like a 3 most important documents they should follow.
Wow, it's difficult, but I'll try. So first of all, the 5 space treaties of UN, of course, are not applicable all at the same time, but at least outer space activities and liability. I think at least that. Then the thinking in Europe, the GDPR as data protection for personal data, and also the new rules about artificial intelligence, because in an automated activity like space, automated and artificial intelligence is important. So second, first, treaties of UN, European regulation about data and artificial intelligence. There is also another document in this second point about robotic from the European Parliament, very interesting for design, manufacturing, and management of robots. In fact, a satellite is like a robot. So have the, and third document can be the national regulation of your space agency, if you have, or if not, at least the regulation, as I suggest, about spectrum, communications, telecommunications. This is regulated through European regulation. This is a big third regulation, but also there is, because it's a directive, there are many national regulations to transpond that. So 3 more or less.
Yes.
It's a difficult question, just to summarize how much.
Yes, I understand. There must be a lot of documents defining space law. So yeah, but it's good, to start somewhere. So it's good to hear the big 3 that you should rely on. So Efrén, that's actually all the time that we have for the questions right now. If anybody has any more questions, you can write down them in chat or reach out to Efrén individually after the presentation. Now we will be going into a short break. So we'll be coming back in 9 minutes precisely. So grab a coffee, grab a cup of water if you like, and we'll be coming back shortly with another topic of intellectual property for space startups. So stay tuned for that, and yeah, we'll come back shortly. Thank you.
Thank you so much. Bye.
So hello everybody, welcome back from the break. And now we will be continuing our presentations to another topic of the day. So Carlos Albareda, a lawyer technology of space law in Bufete, Calvet, will be presenting the topic of intellectual and industrial property for startups in new space. So Carlos, I'll stop sharing my screen and the floor is yours. You can go ahead and start.
Perfect, thank you, Inga. Good morning, everyone. 1 second, I'm going to share. I hope do you see the presentation? Yes.
Yeah,
Okay.
okay.
Thank you, Inga, for inviting us to these sessions and this project. Thank you for Space Hub Network and Space Startup Division. Today, we are gonna see briefly how works the intellectual property in the space sector. For the beginning, I want to explain what is the intellectual property and what are the main blocks that includes intellectual property, how can we protect our IP. Okay, I'm gonna see IP in instead of intellectual property, and we are gonna focus in IP in the projects in the space project and the conclusion. Okay, for that, for the beginning, I'm going to know and to share with you more theoretically what is the intellectual property. Okay, the global meaning for the intellectual property includes the creation of the mind, the inventions, literary and artistic works, as well as symbols, names, and images used in the commerce. Okay, this is the main concept of intellectual property. Here we need to distinguish two main blocks inside the meaning of intellectual property. The intellectual property is the same name, okay, and industrial property. Okay, we are gonna see first the intellectual property. Okay, we know, or we can distinguish the intellectual property because sometimes in some countries we call it author rights. Okay, intellectual property and author rights is the same. This kind of IP protects literary works, photographies, films, all the documents that the space companies like yours can be made, whatever. Okay, as we see later, this kind of intellectual property or author rights can be protected by copyright, and another thing that we will see later. Okay, just for these author rights or this kind of intellectual property is just is not the main IP for the space works, but it is important if you want or if you do some documents that you are gonna share with another companies or with some authorities, because this kind of IP can protect all the things that you can write in a document. Okay, just the main ideas of this kind of IP. Okay, all the works that are protected by author rights is protected a term of 70 years. Okay, since the author death. Okay, we can protect these documents. Okay, I need to think that in your documents. Okay, the documents that you are in your company, if we do some kind of actions that we will see later, we can protect these documents 70 years since the author right, and after the author of death, all that documents can be public domain. Okay, we can all that means that all the people can get the information and can use for our personal interest. Okay, we are gonna go to the industrial property. This kind of IP is the main content of the space industry. Okay, this industrial property can mean inventions, trademarks, industrial designs, and geographical indication. These the main three I can't, or I don't want to go to the geographical indication because they are focused in food. Okay, maybe you can see that if you are gonna go to eat or buy some cheese, maybe cheese or whatever. Okay, the different kind of food, maybe they are protected by geographical indication. But for the space sector, the important ones are inventions, trademarks, and industrial design. Okay, as we see here, the inventions creation, the invention is the creation of a new thing that did not exist. This is important, and this is the main idea of this kind of IP, because not all our objects of our satellites or our components of a satellite can be protected by IP. Okay, we need to know if our object or our creation is a new thing. Okay, that it doesn't exist in the market. For example, I put it here in the presentation. The new observation camera of Satlantis is a Spanish company that I think 3 weeks ago present this camera. This is a particular camera, and maybe, I don't know exactly, but I don't know if it's Atlantis protect this camera, but it can be protected by IP. Okay. The second one, as I said, is the trademarks. I think it's an important thing for the startups and for the companies for the space, because it's a good identification in the market. If we don't protect our brand, anybody can copy the brand and can do the same that I doing. Okay, brands, as I said, allows us to identify, distinguish something. I put here a trademark brand of a Spanish market. I don't know if you know PLD Space. It's a Spanish rocket launcher sitting in Teruel, okay, in the north of Spain. And for the last, and not the, it's important as well, industrial designs. That means devising an object to be mass produced. Okay, if we, for example, if our company buy or make some kinds of satellites or component, and this kind of satellite can be produced we can produce in a mass produce, maybe not always, but maybe can be protected by IP. I try here in example the Raptor 2 rocket of SpaceX. Okay, this is a mass produced engine of the rocket. Okay, just for thinking an example. Okay. For finish the theoretical intellectual property, I would like to share with you that the ideas that it not considered protected by IP. Okay, I will try here the ideas. Okay, it can be patent or it can protect the ideas. All the things that we have in our head or in our mind can be protected. We need to. It's necessary to protect something. Can create it. Can pass the theoretical and the mind thing in a physical idea. Okay, that's a very good important. Or obviously, if we have already an object that is patent before our idea, we can't be protect our idea. Okay, that's obviously. Mathematical concepts for example, I don't know if your company do some software for or a mathematical formulas for something about in space or for a operation of whatever, we can protect that kind of formula because all people, all the persons can get that formula. Okay, this is the formula. The mathematical concepts means that it can protect because where anybody can find the formula to have the results, the same results. Okay. And the computer software, in general perspective, all the software can be patented, but I put the asterisk. In the case of software, they may be registered under the Berne Convention. Okay, the Berne Convention means that some countries, I don't know, it depends of the country that you stay, but I try here an example. Some countries like Spain have the opportunity to register the software. Okay, this is an example. Sorry, because it's in an Spanish form, but here you can see the submit the paper that we need to present to protect our software. Okay. As I said, it depends that the country that you are incorporate. Okay, how can protect the intellectual property? Okay, we saw the theoretical reason, the theoretical concepts. Okay, and we are gonna go to how can protect our creation, our object. Okay, our satellite. I distinguish the copyright for the author rights or intellectual property, Creative Commons, that is a similar protection to copyright. Okay, we will see, and the patent. The patent is the formula or is the way to protect our creation. Okay, that means this is the patent protect the industrial property, not the intellectual property. Okay, that's important. The intellectual property only can be protected by copyright or Creative Commons, and the industrial property just for the patent. Why it's IP4? Okay, I think the main idea here and the main thing to protect our IP is because enable the owner or creator of the work to benefit from his or her work or investment, and avoid the copying of the inventor or the invention. Okay, if we protect our creations, we can develop our project more further than if we don't protect our inventions. Okay, as a friend said in the last session, the patent is not only the way to protect our IP. There are different ways to protect the IP. Okay, but is the last one. Okay, okay, we are gonna go to the copyright. Okay, why the main points of the copyright? Okay, the protects to the author of the work. Okay, this is important. If you can see that symbol, the letter C inside the circle, this means that all the document that you see with that symbol can be is protected by intellectual property. Okay, that's important, and that's good to know to you, because if you are gonna go to share some documents, our expertise and our recommendation is put this symbol in all your documents that you want to protect. Okay. another thing that is important to know, that intellectual property and author rights, it will be protected for the simple act of creating. Okay, if for example, if I do the document, I am the owner of the document, and I am the author of that document. Okay, and for that simple act, I can protect the document. Okay. In the point 3, I put the in the case of the space sector, the main thing and the main idea or the example that we can put in this kind of intellectual property is the instructions for use of a component, or maybe the instructions for whatever. Okay, the component of the satellite or the satellite. Okay. And the point 4, and as I said, remember, do not protect ideas, but rather the expression of those ideas. Okay, that is important. Going to the Creative Commons, as I said, is a different way to protect the author rights. Okay, we have the copyright, the symbol of the C inside the circle, and we have a Creative Commons. Is a free legal instrument, or everyone can use it. And the objective is to facilitate the use of sharing both creativity and knowledge. Okay, as we can see here, we have different symbols, and we can choose each one to protect, as you see, more restrictive or most open the document. Okay, if for example we have a document that is so important for our company, we need to put the symbols that means the most restrictive way to share the content of the document, and you can use those symbols to specify the weight of permission or restrictions that you want to put in the document. Okay. And go for the industrial property. The patents is not the only way, okay, but is the main way to protect the IP. Okay, first one, the way to present or to protect the IP is submission of the application of the authority. We will see later the different ways to present this submission. But here I put the logo of the WIPO, that is the World Intellectual Property Organization. Okay. Analysis of the product to be patented. Okay, that's important because as we saw, sorry, not all the products can be patented. We need to determine what specifically what product we want to patent. Okay. Analysis of the invention, the things that did not exist before. Obviously, we need to have a clear idea. Sorry, we have a clear idea of if the object that we want to be patent exists or not exists. Okay. In the process to get a patent, we have a period of time that the competitors or other companies can be present some submissions about your patent, because sometimes, for example, if you want to patent a satellite, maybe there are a similar company of yours that they patent a satellite before you. You will go to a period of time that your company and their company come competitive. They gonna fight for this patent. Okay. And just just to know, the data of 28 and 42 months is the period of time of the decision to be to finish the period of the processing of to get a patent. Okay, this is in Europe. In Europe, if we want patent some kinds of region in different countries or in different countries, maybe that period of time can be reduced or increased. Depends. Okay, the intellectual property in the space project. Okay, I put here a photo, a picture of a CubeSat, because here we can see the different the composition of that CubeSat. I think it's a great picture because all that things can be protected by IP. Okay, depends of the specific case, but in general terms, we can protect that kind of parts of the satellite. Okay, the tips, main ideas for IP protection. Okay, obviously, if you are gonna share in some documentation, it's important have secure all that document. Okay, and obviously, what content do I want to protect? It's impossible to protect all my activity because it's impossible. We need to focus in the main ideas that we want to protect. Okay. I obviously you do, but it's obviously if you are gonna share some documents or some information, is highly recommended firm an NDA or another contract or a contract or wherever, but a firm signature, sorry, a documentation to protect that information. Here in our experience in the Bufete, we are including clauses, penalty clauses. Okay, that means if the other company breach some of the clauses of that NDA or contract, they pay to us an amount of money. Okay, we can determine that amount of money depends of the object or the document or the information that we want to protect. And another important thing, the determination of applicable law. That's important because sometimes we are talking or we are working with another companies that are not incorporated in the same country than us, and we need to determine what is the applicable law of that contract or that NDA. Okay, as you know, we have there are two different way of determination the applicable law. We can choose the ordinary laws, like the ordinary process, sorry, or the arbitration. Okay, different patents. Okay, as I said, there are three levels of protect our ideas. Oh, sorry, our creations. The first, the national patent. Okay, I put here the logo of a Spanish officer in charge of patents in Spain. Here you can, if you choose that kind of protection, your product or your invention just is protected in the national region. Okay, not for the rest of the world. We have the European patent. This is the second level, and you can protect your creation in all the economical European space region. Okay, and the last way or the last step for protect our ideas is the international patent. Obviously, depends that depends of the protection of our creation, the cost increase or decrease. If we choose the national regulation, it will be more cheaper than the international patent. Okay. Benefits or importance of the IP in the space sector. Okay. Boosting investment and innovation is obviously if we can protect our ideas, we think about more ideas. If our ideas can copy in the first day that I invented, obviously I am not incentivized to create more. Okay, need to protect the inventions, increase the financial investment, and increase the technical and legal certainty. Okay. Just for the conclusions to finish in time, I think I want to explain four main ideas. IP protection is a core asset. Okay, this is the heart of your company. You need to protect it. If you don't protect or you share, for example, documentation or information without the signature or documents of the contract, you are losing your core. Technical and legality must complement and must complement each other. Obviously, as Efrén said in the last session, technique and legality they need to work in the same time. Okay, protection of investment made. Okay, you spend a lot of. I'm sure that you spend a lot of time in your satellites or in your components or in your software, and you need to protect it. And this is the mechanism. This is the rule to protect all your creation. And legal certainty is essential for the project. That's the main ideas. I open to thank you very much for the organization, and I open to answer all the questions that you have. Thank you very much.
Hi, Carlos. Thank you so much for your interesting presentation on intellectual property rights. And now we have some time for questions. We have already one question in the chat from Justina. She is asking Carlos, what is your personal opinion in terms of patents and space industry? Would you say they're imperative, or do they slow down innovation and progress?
I think if we talk with a startup, our recommendation is go progressive, because if you won't go through the patent, obviously the price of patent something is very high, and we need to balance the economical life of the company and the startup and the price of the patent. There are some mechanisms that can protect the idea or the invention before or to get a big patent. Okay. Yes.
Thank you, Carlos. We have a question from Sean, who has his hand raised.
Yeah. Hi there, Sean from Big Adventure Tech. I have a comment, right, just to add to that. The thing about getting IP, copyright, trademark, and trademark press is correct. The issue with patents is everyone tries to do it on a budget, and that's where they go kind of wrong. So, for example, in the US, where we have startups, you have if you share your idea or innovation online in public, okay, you have 12 months grace to file your patent. In the UK, if you do that, okay, you have 0 months grace. totally mutually kind of exclusive. So my suggestion is that the cheap patent, for example, in the UK covers 30 countries. The one in you just pay for the expensive one because it will save you the money in the long run. In the UK, it's about £5,000 to do that, to file the patent. So just be aware, you know, don't confuse, you know, don't confuse, don't try and penny pinch with sorting out the patent, because it will bite you in the long term, especially if you're trying to negotiate with savvy investors. They will ask for IP assignment and put your whole business at risk, even though they're taking 5 to 10% equity, you know, in your business, in that kind of resolve. Okay.
Yeah. Of course,
yeah,
I agree with you. I agree with you. Yeah.
Okay, Carlos, any further comments on this? What Sean just shared?
Yeah, so the reason why I say that is we actually have in-house some patent attorneys. So if you want to DM me, we actually do searches, audits, valuations, and we can show you how to do an IP raise in terms of increasing your pre-money, okay, the asset value of your organization for your space innovation, okay, aviation, aerospace space on hand. So if anyone wants to DM me, then let me know. I don't want to hijack the event. Okay, thank you.
Sean, thank you very much for sharing. Maybe we have any more other questions from the audience. You can also post the questions in the chat if you do not want to speak out loud. If not, we also have some questions from our side to Carlos. So Carlos, could you tell us what problems can space startups face if they do not consider the IP protection? So maybe there are any well-known cases that you could share with us.
It's a good question, and as Shen said, we need to focus in the specific project. I can say this part can be protected, or this can be protected. We need to study the specific case. Okay. There are a long period of time to study. There are the companies that they want to be patent some components or some inventions. They need go to a lawyer, to an external lawyer, to ask and to present all the questions that they have, to resolve it, because we need to check if that, as I said, if the invention is already patented or not patented. We need that if the invention is potentially patented, because there are some points that the thing that we want to patent, they can comply with. I can say to you, Inga, if what kind of components can be patented or not. We need to study the specific case.
Okay, I see Sean has thank you, Carlos. I see Sean has a question again.
Yeah, I have another comment. The thing about patents is they're intangible, so you can't pin it down as to what it is. So the real thing to be careful of, as I said, I can't overstate this enough, is with a patent, you can actually use that to increase your pre-money if you apply for an IP license. Okay, but if you go to an investor and ask for investment, and you say, yeah, well, you know, I'm just searching, I'm just finding it, because it is an expense, right? They will use that against you when they do their due diligence, because once they see that you haven't got the patent file, and they might like the idea, they may have a prime contractor like Raytheon, Boeing, whoever, who might be interested in your innovation, okay, and sell and ask for IP assignment, because they're giving you 100,000 or 200,000 in your initial raise, okay, and then sell your IP without lifting a finger for 900,000, okay. and when they sell your IP, even though they've taken 5% or 10%, they will effectively put you out of business, and whilst you've invested all your savings into your startup. Okay, so it's very important that one of the first people we found at Big with Venture Tech, we hired 3 patent lawyers, and we're also affiliated with a research university who will search and audit like your patent and also show you how to improve it as well. So if they find something similar, they'll tell you, hey, you need to do this. So so that's why it's important. You can't put your finger on it and it says, oh, I'm paying this money, okay, all this money for something that's intangible, then that's not physical, it's not software, okay. So don't try and fire your IP on a budget, okay. You can go to a subscription model, okay, but yeah, you want to resolve that or check that out before you invest or use your credit cards to fund the business, okay.
Okay, thank you, Sean, for sharing your thoughts on this again. Does anybody else have questions from the audience? First, still free space for you to ask questions. If not, maybe I can ask one from my side again. What types of penalties could occur if somebody infringe on someone else's intellectual property rights? So, for example, if you breach somebody else's intellectual property rights, what would happen?
Sorry, can you repeat, Inga?
Yes, of course. So what types of penalties could I, for example, if I'm a startup, incur if I infringe on somebody else's intellectual property rights?
Okay, depends of the patent. Here in the law firm at the moment, we are working in a infringement of a trademark, not in a patent, but in a trademark. And the first step is not you need to pay an amount of a fine, or is more complex. The company that see that the patent is infringement with another company, they ask you before present a claim or a reclamation, saying, hey, you are using a patent that it's my patent. Stop your activity, or stop whatever. Okay, and if the company do nothing for that notification, this is the second way is present a claim. And depends. We don't have, or the legislation about it. We don't determine. They don't determine the specific fines for infringement of a patent. Then we need to go to the specific patent. How is the amount of money that costs the patent? What is the product that is patented? And calculate in a global terms the amount of money.
Okay, thank you, Carlos. Sean, yes, if you want, you can add a few more things, but we are about to finish now.
Yes. So I'll be quick. Sorry, because I'm very passionate about this part of like start. You can see because it's very contentious. From our experience at Big Win Venture Tech, generally what happens, from what we've seen with other startups, they if it's like a big prime, they generally get like a letter to say, oh, with a period of grace, change your product, and there's really no immediate course of action. But obviously, if they continue, and then the IP licensor, okay, sees that, then yeah, it'll go straight. It could be very litigious, i.e., they'll drag it through the courts basically, or drag it through the laws, and it just becomes really, really expensive. Even though I've seen companies that have, there's a good example of this outside the space sector, Pinterest, for example. Yeah. They had an example where they're making revenue, but even to this day, from when they got into business, they're still going through the courts, having to, and that can hurt your revenue run rate. And an investor does not want to have that kind of negative exposure, even though your business might be making money, you know, as a result of the, you know, any infringements, or even if you've changed like your patent, okay, that will make an investor run a mile. That's what I said. Thank you.
Okay, thank you, Sean. So if there are no other questions, oh, I see a question from Phil actually. What is the benefit of IDEE? Does anteriority help with the IP?
What? Sorry, I don't understand what is depot.
Yes,
Okay,
Phil?
maybe I can explain. There is a hello everyone.
Hello.
There is a system in France called envelope, solo envelope. And there is a system in Belgium and Netherlands called IDEE, in which you just put your documentation online. You basically put it online, and it's kept online with the proof of the date you've put the information. So that provides you with, I would say, a date when you, I would say, had the document issued. And some people claim that this could be helpful with, I mean, to protect yourself, based on the fact that you can state that you had this document issued at that date, and that could prove that basically for a patent, for example, you were working on the subject before someone else. So I just wanted to know whether they could make sense, or is it just very partial as a protection, or zero protection at all?
I think I don't know specifically that process. Phil, sorry, but of course I think that could be interesting for the companies that help for the companies to protect the IP. I don't, sorry, because I don't know exactly that kind of the process or electronic process, or sorry,
okay.
but
there is very specific for France, Belgium, and the Netherlands, I think.
Yeah.
Okay.
Maybe if you are interested, I can study this specific process, and we can talk about it later by email or.
Okay. Thank you.
Yeah, I would agree with you, Carlos. I've never heard of an IDEE. The only thing else is that a license? Is that an IP license?
No, it's
France?
just basically, I mean, the process in France is in place for many years. So basically, you buy an envelope and you send it to the IP office in Paris, and there they stamp it. They keep it, one example, and send you back with a stamp an envelope that says basically we received it at this date. So you just state by this that basically this documentation was issued by your company or yourself at a certain date. This is the only thing that is.
Okay, yeah, I think what you're saying, that's the application. So like in the UK, we go to .gov.uk and you file the patent application, and it takes 6 to 8.
Yeah, it's not even an application. It's just sending the document that you would do if you go to a lawyer and have it registered, like you would have for your home or whatever. So you register a document with the date. So my question was, well, does it really help in any way to basically, when you develop a technology, to basically document the progress of your technology by just having an official stamp on your documentation saying that you have done this at this stage, and you document step by step?
Yeah, I don't know. I don't agree with Carlos. It's not something that I've seen, but it sounds like if you in a court of law, you probably could argue if it's approved under EU law. I think that's what Carlos is, would try and do, is do a search to see if it's validated under EU law. And then if that's the case, then fine. You know, it's not something I've personally heard of.
But maybe Phil is interesting because if you can prove the date of that deposit or that registration of the invention of the object, maybe it will be helpful for a future claim, you know. I don't know if it's free or we need to pay. I don't know.
The cost is very low. That this is a possible interest of this thing. I mean, it's probably 20 euro or 50 euro per deposit, which is not, I would say, a great cost. But I wondered really what would be the value or the benefit of such an approach.
Efrén.
Okay, thank you.
Inga, if I have time just to offer some vision on that, I think we have to distinguish, at least in the European IP protection framework, the distinction between the right, who have the right and what is the right and what is protected by that right, and how you register that you are the owner of that right. And also, as Sean talked, I think quite well, and Philip, as you explained, we also have in Spain a system in which we can prove the right I have. Imagine through like that iDepot, we can present a deposit into a notary just to prove against third parties who are the owner or the creator, as the European directive says, and what is the right protected. So I think there are systems like Creative Commons, a system used to show who is the author and what is protected by IP. So we have to see in each country.
Okay. Okay, thank you, Efrén.
Yeah, sorry, I just to add to that, I just went onto the website. It's the Office of Benelux, and it says, an iDepot does not confer intellectual property rights, and therefore it's a notarial deed. I don't know what a notarial deed. It provides no protection. So I think it's just like the beginning stages. So yeah.
Okay, thank you everybody for this fruitful discussion. Unfortunately, this is all the room we have for the questions today. Sean, thank you very much for you being so active and jumping in.
Yes.
It's always great to have a discussion. So we reached the end of our session for today. Carlos, Efrén, thank you very much again for your presentations. I hope it was useful for our startups as well, working in the space industry. And now I would like to, while closing the session, just to head in on what waits next for the day still. So on 1 o'clock, we'll be having another session, which is called Space Accelerators Matchmaking Session. So we have an exciting bunch of accelerators joining us. So to be more specific, we have Seraphim Space Camp Accelerator, Starburst, ESAPIC, Space Founders, and Techstars. So stay tuned for that. We'll be starting again at 1 o'clock. We'll be hearing their presentations, and we will be doing some group sessions where you will be able to ask some questions. So thank you all again for today, and we'll see you in 1 hour then. Thank you. Bye-bye for now. Thanks, everyone.
Bye.
Yeah.
Bye.